Good evening, sir. We are live now that Chief Just Judge. How are you? How are you this evening?
I'm doing well, and yourself?
That's good. Just fine. Good evening, everyone. I'm Jack. I'm thrilled to have with me tonight on the Let's Talk show on Urban Cast. As always, we are here to bring you insightful conversation with leaders who are shaping our communities. Tonight, we have the honor of speaking with Chief Judge John Michael Guidry, a candidate for Associate Justice on the Louisiana Supreme Court. Before we dive in, everyone, we want to encourage everyone to engage with us by sharing this broadcast and asking your questions. Remember, one of our key goals is to inspire everyone, especially our young voters who are now the majority, to get out and vote. Your voice matters. Together, we can make a difference. Judge Guidry, we're excited to have you on the show this evening. Could you start off by introducing yourself to our listeners and sharing a bit about your background?
Yes, I'm Chief Judge John Michael Guidry of the Louisiana First Circuit Court of Appeal. I have been a member of the Louisiana First Circuit Court of Appeal, which is an intermediate appellate court just below Louisiana Supreme Court. I've been on this court for 26 years. Prior to being on the First Circuit, I served for a year in the Louisiana House of Representatives. I served for close to 5 years in the Louisiana State Senate. I taught for 25 years in the Nelson Mandela School of Public Policy, and I continue to teach in the Southern University Law Center, where I have been teaching for about 35 years now. And so I have taught the law and continue to teach the law at the Southern University Law Center. I have made the law as a member of the Louisiana legislature, and for 26 plus years, I've been interpreting the law on the Louisiana First Circuit Court of Appeal. Um, I am also the chief judge of the First Circuit Court of Appeal. I am the first African American chief judge in the more than 120-year history of the First Circuit Court of Appeal. I believe that that combined experience makes me the best possible candidate to serve on the Supreme Court. On the Supreme Court, experience matters. It is an important court. It is the highest appellate court, and a person who has 26 years as an appellate court judge certainly is prepared to sit on that court. I liken it to a situation of a hospital because the work that's done on that court is life and death. I actually had a friend the other day who was preparing to go, excuse me, into heart surgery. And when she was preparing to go into heart surgery, she was not concerned, even though she was a female, she wasn't concerned whether the surgeon was a male or female. What she was concerned about was whether or not you had the most experienced, competent, um, prepared surgeon to go in that room with her. The Louisiana Supreme Court is life or death. Certainly, death penalty cases come to that court, and to the extent that there is error, once a person is executed, you can't correct that error. So you want the person dealing with the lives of individuals to be the most experienced person hearing that case. Similarly, cases come before our court where individuals are facing incarceration. So we're dealing with people's liberty. And it may be a situation where you're about to lose your property. So literally, life, property, liberty is at stake when you come to the Louisiana Supreme Court. And just like my friend wanted the most experienced surgeon in that operating room, you want the most experienced judge that you can in that courtroom deciding those decisions that affect your life, your liberty, and your property. In this particular race, I have 26 years on the Court of Appeal. I have an opponent that has a few years on another court of appeal, and I have another opponent who has never been a judge at all. So I have one individual that I would liken to someone who's never been in the operating room. I have another opponent who I would liken as a resident who's just sort of trying to learn. And I liken myself to that experienced, qualified, skilled surgeon that's in the operating room. And so I think that that's, what distinguishes me in this particular field is that experience. And again, when you're dealing with life, liberty, and property, experience matters. And on the highest appellate court in our state, where their decisions are final with regard to state law matters, you want that experience on the court.
Let me ask you, for a lot of times, a lot of us don't understand basically the way that the court system is structured.
Yes.
You have the district court, the appellate court, and then the Supreme Court here in the state of Louisiana. Can you briefly explain the differences between the three of those?
Yes. So mostly what individuals are familiar with are the trial level courts. That's what they normally see on TV. That's what they normally read about in the newspaper. That's what they normally see on the news, the trial level courts. So once you have been at the trial level in the state of Louisiana, constitutionally, you have a right of appeal to my level of court, which is the intermediate appellate court. You have a right of appeal. The only types of cases that bypass my court is when the death penalty is actually imposed, and you bypass my intermediate appellate court, you go directly to the state Supreme Court. If you get a life sentence, then your right of appeal is to my court in a murder case, capital murder case. And in an instance in which the district court declares a law to be unconstitutional, then you bypass my intermediate appellate court and you go directly to Louisiana Supreme Court. In all other instances, you have a constitutional right of appeal to my court. And then in 7% of the cases that go before all of the 5 intermediate appellate courts in our state, the Louisiana Supreme Court takes up about 7% of what has been decided by the 5 intermediate appellate courts in the state through what they call the grant of a writ of certiorari, which is a discretionary order to my level of court to send the record up to them for their review. So as a practical matter, in 93% of the cases, my level of court, my appellate level, the Supreme Court is an appellate court as well, but the intermediate appellate court that I sit on, our courts are going to be the last stop with regard to state law matters unless the Louisiana Supreme Court grants certiorari, decides to hear those cases. And again, they only do that in 7% of the cases. And like I said, the only way that you're going to have a right to go to the Louisiana Supreme Court is when a death penalty has actually been handed down, or when a law has been declared by the district court as unconstitutional.
Wow. Okay. Thank you for that. Thank you for that. That bit of information there. You've had a remarkable career, and I'm gonna go away. I'm gonna deviate just a little bit. Just a few minutes ago, just looking at you here on the screen, and when you went over your background, I was like, you're too young to have.
Well, I've been blessed. I started out, like I said, as a legislative assistant to Joe Delpit in the legislature, and when he retired, I replaced him in the House at a very young age in the 20s, and then went on to the state Senate. When Senator Cleo Fields went to Congress, I replaced him in the state Senate. And then when Judge Freddie Pitcher retired and went to Southern University, he first went to a law firm and then Southern University Law Center. But when he retired, I completed his unexpired term and have been continuously reelected to my court since that time. So I started out pretty early, like I said, right out of high school, working in the legislature. And as I got into, a little bit older, I got elected to the House.
I know you said that you want that person that has the experience to be there on the Supreme Court. Well, from that guttural standpoint, what motivated you to say, hey, this is a position or a place in servitude that I can go in and I can make a big difference? What motivated you to do it?
What motivated me to do it is that I had a lot of interaction with the Supreme Court. I was a member of the Judicial Council on two instances where I served 3-year terms. With the Judicial Council is a entity that is a Supreme Court body that basically does research and try to improve the judiciary, looks at whether you need new judgeships, whether you need fines or fees. I represented all the appellate court judges throughout the state, twice elected by them to serve on the Judicial Council with members of the Supreme Court and with members of the public and district attorneys and clerks of court. I served by virtue of being a chief judge on the Judicial Budgetary Control Board, which comes to the Supreme Court with approved measures to be presented to the Louisiana legislature for funding. We sign off and the Supreme Court signs off, and then when the money comes back, we again weigh in, and then the Supreme Court weigh in. Again, I serve on that board with other chief judges of the Courts of Appeal and also with Chief Justice and other justices of the Louisiana Supreme Court. I was appointed by the Supreme Court to the Louisiana Judicial College, where I chaired the Louisiana Judicial College and continue to serve on there in a non-voting capacity as a former chair of the governing board of that group that is charged with educating and training judges throughout the state. Every time we have a new class of new judges, I teach new judge training. And so I've been dealing with the budgetary aspects. I've been dealing with the administrative aspects. I've been dealing with the educational component. I'm also a member of the Supreme Court's Technology Committee, where the Supreme Court appointed me to work with the technological needs of the entire judiciary. I'm also part of the Judges in the Classroom advisory group, where we try to get judges to go out into the schools and to bring students to the courtroom. Now, I've been doing that before I became a judge for over 35 years. I spent a great deal of time in classrooms, in churches, because I believe if young people can see it, they can be it. And
Right.
I try to reach out to them on the front end so that I don't have to have their cases sitting on my desk in the back end. And so I also am a instructor in the faculty for domestic violence. I go around the state through a Supreme Court program that's called LPOR, Louisiana Protective Order Registry, and I go and train judges in particular about handling domestic violence cases. And then I also go and present to lawyers and to other partners in the judicial system about properly handling these domestic violence cases, because I feel so deeply that we're losing too many lives as a result of domestic violence. And so that interaction with the Supreme Court allows me to hit the ground running on day one, because I've sat on these committees with the justice of the Supreme Court. I've interacted with the staff of the Supreme Court, and I have, through those positions, worked with judges and lawyers throughout the state in continuing legal education and in matters of new judgeships and fees and fines. But more particularly, because I've been an appellate court judge for 26 years, that's what the Supreme Court is doing. The Supreme Court is basically grading the papers of my court, and I grade the papers of the trial level courts. And so I'll just be looking at the same body of work that I'm producing right now. And so and there have been so many instances in which the Supreme Court, even when I have not authored a decision, they have taken my dissent and used that as a basis for granting certiorari. And then when they reverse, they will cite my dissent as a basis for reversing. So whether I get there through a dissent or I get there through being the writer or joining in a majority opinion, I have interacted and understand the workings and understand the expectations of the Louisiana Supreme Court. So my thought was, who better to serve on the Louisiana Supreme Court than somebody who's had that very practical and direct interaction with the court in all these different capacities in the past and ongoing, who has, taught the law, continues to teach the law, who made the law, and who have basically interpreted the law for 26 years. And I think that it is very important on the highest court in the state to, give your best, most qualified, experienced person to sit on that court. And I thought, based upon my resume and my experience in the judiciary, I was that person. And again, so as I've done for all of these years, I offered myself up for service on our state's highest court.
Wow. One of your priorities is ensuring that our courts are more accessible to the public through technology.
Correct.
How do you envision implementing this? What impact do you think it will have on the judiciary system, at the local area?
Um, I believe that to the extent that the Supreme Court supports and provide any necessary rules and funding, then people will have more access to justice in one way, in terms of the fact that we have so many people who are self-represented litigants. We used to call them pro se litigants, but we now call them self-represented litigants. And to the extent that you help to facilitate those individuals getting access, whether it's through pro bono representation of private lawyers, whether it's through various entities like in Baton Rouge, we have Southeast Legal Services, we have bar associations who, again, encourage their members to do the pro bono work. And in some of our courthouses, we have set up situations where we have self-help desks where we have lawyers available, for example, in the family law court in East Baton Rouge Parish, where we have established these self-help centers, and not only with having some live individuals there, but having forums and also working with the clerk of courts. When people come in who are self-represented, they can't give them legal advice, but they can give them the right forms. They can give them some direction and instructions in terms of how to access the system. Similarly, through technology, to the extent that we recognize that COVID has taught us that you can make the courts more accessible through technology. So to the extent that persons are not able to travel, there are many hearings and there are many things that can be accomplished through the use of the type of technology that we're utilizing today. A lot of places during COVID and currently have gone further in terms of the use of smartphones and other ways in which to allow people, and even when they don't have smartphones, to allow them to just dial in. We allow this type of communication with individuals who are incarcerated, where they can access hearings with judges through videos and through telephonic means. And so we should make that equally available to individuals who cannot necessarily get to the courthouse. And then when they get to the courthouse, we have to have programs in place like drug courts, like veterans courts, and domestic violence courts, and all types of specialty courts that will facilitate, individuals getting the help they need. The answer is not always incarceration. Many instances, the answer is treatment, and the answer is, so to the extent that you can't get in a pretrial program, then maybe you can get in a substance abuse program. Maybe because you are a veteran and we can provide and help you access services that are available to you as a veteran, then rather than immediately sentencing you, we can work with you, recognizing the needs that you have and the service that you have given. So veteran courts, same thing with domestic violence courts, we can deal with some of the underlying issues, that lead to domestic violence. And so once you get to the courthouse, then you ought to be able to access programs that attempt to make sure that you get an education, that you get drug treatment, that you get some help for whatever the issues are that are bringing you into the court. Similarly, we need to make sure that when individuals are accessing the court system, that we are working with community partners to help to provide some resources and to direct them to some resources that will ensure or attempt to ensure that they are not recidivists. We also have, for example, reentry court. So when people have been released, then through the reentry courts and the reentry services, again, we are trying to reduce the recidivism. So I think, and another thing that Supreme Court does is working with programs such as CASA. The legislature funds the judiciary, and we work with the funding of these CASA programs so that these individuals will have someone who will work and to help particularly these young people who are going through this process. So again, there are many programs. There are many technological innovations. There are many specialty courts. There are many areas such as self-represented litigants and pro bono and things like HASA that the Supreme Court can do to make sure that not only individuals have access to justice, but that when they come into contact with the justice system, it is about help and to make sure that we they don't have to return, particularly in the criminal context.
You in one document that I read that you made some comments about, you talked about the workload study for judges.
Yes.
Could you elaborate a little bit about why you believe this is necessary and how could it benefit the efficiency of the courts?
Again, with particularly with the economy that we are facing,
Hmm.
I think people want to know that they're getting the best bang for their buck in terms of funding any governmental enterprise. And so, all the case study will do is to give us some empirical data to show what the workload is with regard to respective judges and and thereby their respective courts, and it will be something that can help inform the appropriations process. And so basically, the way that we have gone about getting new judges is that in the Judicial Council that I serve on also has some committees, one of which I serve on is the new judgeship committee. And when a particular locale requests that they be awarded or they be given another judge, then we are charged as the Judicial Council's committee on new judgeships to evaluate the need for that judgeship. One of the ways that we do that is we go do site visits and we receive from the various courts what the workload information is and why they need a new judgeship. Well, we have been operating on a formula that is outdated, and so in order to update the necessary criteria and formula for making that assessment, we needed to do a new work study, work point study. And what that does is it says that, on this particular day, I worked on this many appeals. I worked on this many writs. I spent this much time doing administrative work. I had this many cases assigned to me. This many cases are assigned to our court. And maybe even some discussion of the complexity of the cases I had. Same thing with my law clerks. This is what they have worked on. And so what that allows you to do is to say that this particular circuit, for example, has X number of cases. It takes them this many hours in order to process those cases, and therefore, if it takes a judge this amount of time to process a case, and we know that the number of cases that this particular circuit or this particular jurisdiction has, then we are able to better assess how many judges are needed in that particular geographical area. But without looking at the work point study and to see how judges are utilizing their workday and how much time it takes them to process how many hours, how many minutes, how many hours, and how many days that it takes for them to handle appeal, to handle a writ on the at the trial level, to handle a murder case or to handle a an accident case. Then it's difficult to be informative in terms of how many judges are necessary. And of course, along with a judge comes staff. And
Hmm.
so, again, and along with judges and staff comes chambers. And so, to know how many courthouses you need, and how many judges, and how many lawyers, and how many judicial assistants, and how many clerks of court, you need some empirical data. And the data that we have is outdated.
Right.
And I just believe that, it would help the citizenry to know that we are good stewards of their tax dollars by showing that we have no more than we need in terms of judges and staff in order to do the work that we are actually doing. And I think
Right.
that is a reasonable request of judges to participate in such a study to provide that empirical data.
Being data driven is something that's just really important in our community. It is refreshing to hear you talk. I come from the IT arena, so when you start talking about the data driven and and basing our decisions on what the data is actually showing us, that's really important. Um, that being said, I'm going to go off onto a little bit of a tangent. Why do you believe, Judge Guidry, that as important as the legal system is to everybody, a lot of times we don't see it because we don't actually have to fall through the hoops of it. But why do you believe, like in this election, your position that you're running for right now, in my opinion, after 16 years drilling in a JAG unit and that kind of thing, I know just how important it is personally. How important. Why don't you think we put a lot of emphasis on the makeup of the judiciary system and what's happening right now? This whole election surrounding it, because a lot of there are a lot of people that get impacted by the judiciary,
Right.
and it just seems like in comparison to some of the other elections going on, oh well, but this is something that's really critical. I mean, you see so many um, nonprofit organizations that are advocating on behalf of criminal justice reform and different things of that nature. And I guess I'm just kind of lost a little bit. Why don't we see them talking about this important election right now?
I think that, like in most situations, until you have to uh, be involved in the judicial system, it may not, because we are a separate, coordinate, co-equal branch of the government. However, most individuals are in more constant uh, involvement with the other branches of government, with their legislators and with their executive branch members in terms of day-to-day services and
Hmm.
day-to-day regulation and day-to-day taxation and day-to-day issues that impact them from the governmental standpoint. Until they have a case that actually involves them in the judicial system, then I think what they have to realize, though, is kind of late then, because you need to be concerned on the front end about who is elected to the judiciary, because once they are elected, they have a term of office, and your case may get before them during that term of office. And so, as with every elected position, you don't wait till the legislature or the Congress is seated to be concerned about who sits there, because once they're there, then of course that's going to determine who's in the majority, and that's going to determine who chairs the committees, and that's going to determine basically what the public policy outcome is going to be. Similarly with the executive, once you get the executive there, they're going to appoint individuals to various positions in the executive branch, and they're going to be making some day-to-day policy decisions and executing um, the law. And so, once they're elected, it's kind of late to then say, wow, who is my mayor, who's my governor, who's my president, who's my legislator. Same thing with judges. I think you ought to look to, as I talked about earlier, to
Hmm.
make sure that if you're ever in the operating room, if you're ever in the courtroom,
Right.
the person that's going to be handling your matter is a person who is experienced and who has the qualifications, and who is somebody that will be able to handle your matter not only from a substantive legal perspective, but somebody's going to treat you with the dignity and the respect that you're entitled to as a citizen when you come before them. You can gauge those things on the front end, that you have somebody who's qualified, who understands that you deserve access to the court, understand that you have a right to your day in court, and that's going to judge you righteously, as the Bible says. They're going to look at your case, and judge without fear or favor. It doesn't matter your position in life, or whatever. That all they're concerned about what are the facts of this case? What are you entitled to under the law? And
Hmm.
they're going to do that irrespective of any other issues or agendas. They're going to judge you fairly, and you need to judge them, as they stand for election, whether they're going to be somebody who has demonstrated a history. And you can look at 26 years of my body of work as a judge, and you can make some assessments about whether or not you think that I'm going to serve without fear or favor, that I'm
Hmm.
going to be unbought or unbossed, and that I'm going to decide the cases based upon the law and the facts that are presented before me. And so I have a record that I can stand on in that regard, and people need to evaluate that
Right.
before they find themselves before a judge.
Right. Well, and that's why I threw that question at you, sir, is because, now is the time for, we start fighting the battles with the judiciary system, when someone is, they're being prosecuted or what have you, what have you. And now is that time right now to be having that conversation with you. And like I say, there's a ton of nonprofits out there that are into the criminal justice reform, and I just thought, I'm just thinking that they would be all over this. Such a, we get an opportunity to elect the second black justice on the Louisiana Supreme Court, and this would be something that we really need to be talking about. And did I say talking about it? And did I say talking about it again? Because it's just that important, and what have you. Um,
And Justice Marshall did a talk, and what he said, that what we expect in judges, and whether they're black or white, whether they're rich or poor, the only
mhm,
thing that you really expect in a judge is
mhm,
that the judge is going to put aside their own personal agenda, and they're not going to try to exercise the sword that is available to the political branches of the government in order to come up with a public policy outcome that they believe, based on their own agenda, based on their own bias, but that they will simply look at the law and the facts, because judges don't have the sword. What judges have is the role, and that the only ability you have to function is that the people believe that you're operating, in a fair and unbiased way, and that you are making the decisions based on the fact that the prosecutor can't always win, the criminal
mhm,
defendant can't always win, the civil
mhm,
defendant or the civil plaintiff can't always win. It is
mhm.
dependent upon the facts and on the law. And in that tradition of Justice Marshall, I've tried to recognize that when I was a member of the state legislature, I had the sword. I could try to ensure a public policy outcome that was representative of the constituents who elected me. But when I became a judge, some of my constituents are plaintiffs, some of them are defendants, some of
Mhm.
them are, prosecutors, and some of them are criminal defendants. And so judges, have to look at the facts and the law, because when you come before me, what you want is to be heard. You want a decision that is dependent on the facts and the law, and that you get what you're entitled to under the law, that I treat you with dignity and respect. And I think that that is what people ought to be evaluating. Now, if I ever have to go before the court and my life, my liberty, or the property is on the line, or that of my family, that I
Uh-huh.
can go before a judge who is going to judge righteously. And if
Mhm.
I'm entitled to win, I'm going to win. And it doesn't matter who's on the other side. It doesn't matter what that particular judge has an agenda. He's able to set that aside and to do justly, you know?
Right, right, right. Um, the, the the judicial system can sometimes feel distant to everyday citizens.
Mhm.
How do you plan to bridge that gap between the judiciary, the community, particularly the underserved community?
And that's what I do. What I've been doing for 35 years. I spend a great deal of time You can just go on the internet and when my name comes up, he's speaking at this church, he's speaking at this school. So one of the ways that we do that is
So you're not. So I'm sorry, I didn't mean to cut you off, Your Honor. But you're not afraid to go speak in front of folk.
no. You have to. I mean, we have to go and provide civic education, and we have to explain to people that the judiciary is not what you see on some of these TV shows. That this is the way it operates, and this is what it's responsible to do, and this is what you should expect of your judiciary. And that's why we invite students to come to the courthouse and listen to our oral arguments, to view the courthouse. I go to their schools, I go to churches, I go to civic organization, I speak before the Kiwanis, and I speak before the Lions Club and other clubs to do this type of civic education so that people will feel at ease, and they will have a realistic understanding of what they can expect if they are ever in a situation where they have to encounter the judicial system. So I think that's very important. We can't make this some secret society or this some dark chamber that nobody understands. We need to let people know, first of all, it is a courthouse. It is your courthouse. It is a public courthouse. You have access to the courts, and what you're entitled to is to get a result based on the facts and the law, and that you be treated with respect. And I think that's all people really want. They want to know they have access to the courts. They want to know when they get there, they're going to be heard. They want to know that they're going to be treated with respect, and that when they leave there, they can feel like I had my day in court, whether I won or lost. I had my day in court. I had an opportunity to tell my side of the story. I had a chance, and I was treated with dignity and respect. People took the time to listen and to inquire and to, and then explain to me, either through a written opinion like I do at my court, or through oral reasons at the trial court or written reasons at the trial court, explain to me why I won or lost in a way that is, plain language, common sense, that I will understand. If I won or lost, why did I win or I lose? And I think that's a reasonable expectation of our citizenry, who, after all, are paying our salaries and funding our chambers and funding our staff. At a minimum, they should be able to have access to the court. They should be able to be heard. They should have an opportunity to have their day in court, and they should have a well-reasoned basis for the decision that the judge made. So they can, when they get that opinion from my court, I write, an opinion that explains, these are the facts. This is the law that I was required to apply. These are the standards of the review that constrain that decision. And this is why I ruled the way I ruled. And I think when people see that, at least they feel that their rights have been vindicated, or they've at least had an opportunity to vindicate what they believe are their rights. And I think that's all people really, really expect at the end of the day. Well, of course, everybody wants to win.
Yeah.
Even a loss is more palatable when you had an opportunity to be heard.
Yeah, so it's really important that when you have that person who's on the defense of the or whatever, and or the accused, or whatever's going on, your idea is to make sure that both of those voices get heard. I mean, that's kind of inspiring, and and a lot of folk, when you're just sitting and talking around with everyday language and all that kind of good stuff, people are intimidated by the court. And just sitting here listening and talking to you, I feel like I come in your courtroom and we could have a conversation.
And like I said, I welcome that. And like I said, we don't want people to wait until you have a case.
Right.
Invite us in the community to talk about what we do and why we do what we do. Come and sit in on a court case. And come have a cup of coffee with the judge, and talk about what it is. And like I said, when I have the students to listen to the court case, I bring them up to my chambers and I entertain any questions in terms of what just went on. And so I think that is a service that we owe to people. People need to understand the workings of the judiciary, and they need to understand that if they ever have to encounter it, then this is what they should be able to expect.
Judge, I'm gonna say this. It sounds like you're rebranding the court.
Well, again, I think that's one of the reasons why I'm running
Right. Yes, sir.
for the Supreme Court, is because I've had a great deal of experience,
Hmm.
like I said, teaching the law, making the law, and for 26 plus years interpreting the law. And I think I will bring that to the court, and I think that will be beneficial to the court.
Wow.
And so, because what we bring to the court is, of course, our life experiences. We
Hmm.
bring to the court, our unique abilities and talents, and of course, always willing to be constrained, by the law, because ultimately the law has been given through these citizens' representatives. And so we play our role. The legislature makes the law, the executive executes it, and we interpret it. We basically grade their paper to see whether they have made and executed the law constitutionally.
Uh-huh.
And that's what is the power of judicial review,
Right.
to make those determinations. And so I've been doing that for a while, and I think that on the highest court of our state, that will bring a benefit to the court.
Okay. Given the increasing use of technology, AI, social media, how do you see the role of the judiciary evolving in terms of public communication and transparency?
I believe that, at some point we're going to make a move where other courts in other states have moved to have more cameras in the courtroom.
Hmm.
Certainly, the Louisiana Supreme Court, they stream a video and audio of their court cases. At my court, for example, we don't, during COVID, because people couldn't come to the courthouse, we certainly made available by way of video. You could come into the waiting room and be, in the audience to see what was going on. So we made sure there was access to the courts. But I see no reason why, for example, on the intermediate appellate courts where I sit, why we could not, have our oral arguments, um, put out there in the public domain,
Hmm.
similar to what the Supreme Court does now with their oral arguments. The
Hmm.
U.S. Supreme Court, of course, all they do is audio and not video. But I think that there's an expectation on the part of the public when they see news stories from very widely covered courtroom proceedings in other parts of the country,
Hmm.
that they have an expectation that, why not have more of that, in the state of Louisiana. So again, you would have to promulgate some rules and regulations for when and, these particular viewing of court proceedings can be had in the lower courts. But if it's good enough for the state Supreme Court, at a minimum, another appellate court like them should have cameras in these intermediate appellate courts. And then, of course, I mean, you have a whole nother situation with the trial courts. There may be more limitations and regulations promulgated, to the extent that you look at doing it there. But I just believe with technology and this whole idea about transparency and civic education,
Right.
and access to the courts, then I think that, we should certainly, with the technological opportunities we have, we should certainly consider that at the Supreme Court, whether we're going to move courtrooms into cameras other than the Supreme Court.
The, the, the new majority black seat on the Louisiana Supreme Court, which is the seat that you're running for, is a significant development. You know,
Yes.
it took some years to get to where we are at this point.
And I've
And
been a part of that process. I was at the Southern University alumni gala on the campus of the Baton Rouge campus, and Mark Morial,
Mhm.
who I served with in the Louisiana Senate, recounted the fact that it was when he and I were in the Louisiana Senate that we forced a settlement of the Chisholm lawsuit
Right.
that created the only African American seat that we have on the Supreme Court now out of New
In New
Orleans.
Orleans. Okay.
And similarly, we were at the governor's mansion when, along with, say, for example, Senator Charles Jones out of Monroe, we were there with then Governor Edwin Edwards
Mhm.
to get him to keep his campaign promise that we were going to settle the Clark v. Romer and then Clark v. Edwards lawsuit that gave us all of the African American sub districts in the state that now we have per capita the largest number of trial court and appellate court African American judges in the country. We were a part of that as young legislators. And then they did not create African American seats on the Baton Rouge City Court. It was my legislation in the Senate that created the 2 African American sub districts on the city court in Baton Rouge, and now we have a at-large African American seat on the based upon the new demographics in the Baton Rouge City Court. So I've been a part of this work for a long time, so much so in 2012, when there was no African American elected outside of New Orleans, I offered myself up, in a district at the time that was 29% African American. And based on my qualifications and my work in that election, I came within 5.5 percentage points in a district that was 29% African American, when it wasn't the easy thing to do. So you judge people not in times of convenience and comfort, but you judge it in a situation when, they went into a 29% African American district and offered themselves up for service, and said that I am as qualified as any appellate court judge in the state, left alone in the Supreme Court district, and I have a right to run, and the people have a right to elect me. And because of what went on in that particular race, because it became a situation where it became a racially charged campaign, and then use race and race baiting in order to come out with the result they had. My election became the basis of a federal lawsuit in the Middle District of Louisiana, where they looked at my qualifications and they looked at the demographics and they looked at, but for that racial, campaign that was run against me, I should have been on the Supreme Court. And they filed a federal lawsuit and said that's why, under the Voting Rights Act, we need to create a minority sub-district, because in the absence of that, no matter how qualified you are, no matter how experienced you are in this particular iteration of this district, an African American won't be elected. And based upon that federal lawsuit, which I was going to be called as a witness to testify to all of the allegations in the petition based on my race, it was that lawsuit that caused us to come to where we are now, because one of the strong arguments that was made for the passage of this legislation that created this majority minority district was it will allow the state to save millions of dollars trying to defend that suit in the Middle District of Louisiana, and that once we create this district, it will be used as the basis for the settlement of the federal lawsuit. And so that race that I ran in 2012 became the impetus for the federal lawsuit. And it was the settlement of that federal lawsuit became the impetus for the creation of this district. The Bible says you ought not muzzle the ox that treadeth the cord. I mean, I've been in this work, I've paid my dues, I offered myself up. It was not the, easy and convenient thing to do. And I think that, I should certainly have an opportunity to serve on the Louisiana Supreme Court, not because of me as an individual, but what I represented in that federal lawsuit. And what I represent today is the most qualified judge, experienced judge that is on the ballot. And so I think that, when Mark Morial said that, it did my heart well that somebody remembered, who's been in this fight for the creation of these judgeships. And so I think there's no reason that, I not have the opportunity to go to Louisiana Supreme Court and present what I presented when I ran the last time, which was the most qualified. I am the longest serving appellate court judge in the state, not just in the District 2 of the Supreme Court, but the longest serving appellate court judge in the state. And so, and because of my demonstrated ability to, even in a 29% African American district, get the strong support of the African American community and great crossover vote from the majority community, then when, keep in mind this district is 57-43, and so I presented, I believe, the best opportunity to secure the district to have this district in perpetuity, because once an African American is elected to this district, as they will be now, I think that, It's going to ensure that that district remains one in which African Americans can elect a candidate to their choice in perpetuity. But again, what we have to realize is that, creation of these districts, that's not where it ends.
Oh, no, no, absolutely.
Be the first or to be elected means nothing if you're not prepared to serve and serve well. And so when I go to the Louisiana Supreme Court, I will go to the Louisiana Supreme Court elected from a minority district, but ready on day one to serve, with experience and integrity, and with a position of judicial independence, that will equal or not surpass, anybody else that's elected to that court. To put it this way, the people of the second Supreme Court district will be made proud.
Okay.
Person they sit there if they send me there. When I first ran for public office as a state legislator, I was walking around in my community handing out information, asking for votes, and there was an elderly lady who said, "Oh wow, I just hope you don't go down there and make me shame." And that stuck with me as a member of the House and a member of the Senate. And it has stuck with me for the 26 years plus that I've been on the Court of Appeal, that we are not to make shame those who send us there. We need to be prepared. We need to do the work. We need to put in the time that it takes to make the people who elect us proud. So, if I'm elected, when I'm elected to the Louisiana Supreme Court, I believe that the citizenry, both black and white, of the second district will be proud and of the person they sent there, because they sent, like that lady wanted in the operating room, the most experienced, the most qualified person to deal with these real life issues.
Wow, wow. Well, as we get ready to, as we are approaching that election day, um, what message would you like to convey to our listeners and the folk who are going to come back and watch this recording when they get an opportunity to, especially the young voters out there who are just starting to engage in the political process, and not only, and I'm not really just talking about the 17s getting ready to turn 18 or 18, 19. I'm literally talking about the young folk who are just completely disconnected from our elections, period.
Mhm.
What word would you say to them to say, hey, this election matters, and you need their vote? How do you convince them? Because I'm 100% convinced that they will go vote if you ask them to go vote,
Right.
but it's just been cycles behind cycles behind cycles, and it's nothing that's unique to the Democratic Party or anything like that. It's just, it seems it's a part of the just the way things are. We court through traditional media outlets, other election, other offices, but we don't go to where these young people are and involve them in this process. So what would you have to say to them?
I would say to them, first of all, elections have consequences,
Hmm.
and that your failure to vote is really, in fact, shaping the consequence that will result from those elections. And that too many people marched, too many people gave their very lives, too many people had hoses turned on them and dogs unleashed on them. So many people went to jail, and people like uh, Medgar Evers and Dr. King gave their very life to afford us an opportunity to be able to exercise our right to vote. I think that you do a disservice to those who made those types of sacrifices if you fail to exercise your right to vote. And again, for example, the Supreme Court seats are 10-year seats. You won't have an opportunity for another 10 years in order to weigh in. And there's going to be many issues that are going to come before the court, realizing that whatever that's done in the legislature, what's ever done in the executive branch, is all subject to judicial review in terms of whether or not it's been done constitutionally, whether or not it's been done properly. And because the Louisiana Supreme Court is the last court that's going to decide these very important state law matters, you want to make sure that you weigh in on who's going to serve on that court. And what you want on that court is the person who has the most experience, who has the intellectual and academic preparation to go in there and to deal with these very complex matters. Because again, if you get up to the Louisiana Supreme Court, it's pretty serious business. It's the 7% of the cases they take are the most complex and the most life altering, impactful cases that you have. And when again, when you have that type of situation, you're not playing checkers, you're playing chess,
Mhm.
and so you want to send, the best and most qualified person you can there. You don't want to wait until you have to be in front of a judge to find out, that that particular judge does not have the requisite experience and training and commitment to the law and commitment to fairness and access to justice and to, deciding your case based on the merits. Because again, the next time you get a chance to weigh in, your case is going to be over with.
Yeah.
And like I said, these seats are 10-year seats. And so I think it's important that people go out and vote.
Well, Your Honor, I'll say right off bat, I thank you for coming and and actually voicing that concern in a place where young people are consuming information. I
Yes.
think a lot of times, a lot of our elderly folk are, the seasoned among us. We make that statement, but we make that statement on media platforms that the young persons are not even hearing you on. So you don't even appeal to that part of their conscious when you're there. So I definitely thank you for coming over to UrbanCast, and having that part of the conversation with us.
Well,
Um,
I thank you, and I thank you for this forum. I thank you for again reaching a demographic that is often, misunderstood and who are not allowed to have their voices heard and to receive directly the information that they need to have. Again,
mhm.
um, our young people are our future. When I
That's
talk
it.
about the civil rights movement and all of these people who died and marched, and it was the students
Okay.
who did most of the riding of the buses for freedom, who
Right.
sat in at those counters and had billy clubs, who were killed, Smyrna Goodman and Cheney, who basically did the sit-ins, who did the marches, who received the brunt of the dog bites and the water hoses. It has always been students. It has always been our youth who have
Hmm.
laid their very bodies, as sacrifices in order to propel us, as a people. And so it is important that that same sense of activism, that same sense of engagement, that same sense of making sure that we have in place what is going to be protective of our rights and of our future,
Hmm.
that we have that same zeal in this generation that has been in generations that have been gone before. John Lewis got in good trouble.
Good
You
trouble.
know,
I love that concept.
he
Believe it or
did it. He
not.
did it as a young person. A lot of people saw him in
Uh-huh.
his later years as a congressperson, but he
Hmm.
got in most of his good trouble at a very young age. People
Uh-huh.
that are in your audience today, and so and we've seen a lot of that activism in various settings as young people have protested and have exercised their right to speak truth to power. And again, it's not just marches and it's not um, just those types of activities, but voting is an integral part of that process. Yes,
I tell you what, you're welcome to come back anytime, and
I appreciate
you,
that.
and that kind of. It was definitely refreshing having a conversation with you tonight, Judge Guidry.
Thank you.
Um, I definitely want to say, before we go, did you have anything that we didn't cover that you think you just gotta is on your chest and you gotta get it off your chest? You have anything else that you need to tell us?
Well, it's just that in the world in which we live,
Mhm.
um, I think that is important that we understand that elections have consequences.
Yes,
And
sir.
all elections have consequences, and particular elections that may put people in place that's going to deal with your life, your liberty, and your property. You want to make sure that you weigh in and that you know put your best foot forward, put your best candidate forward. And so, if you are ever the one that has to stand um, before the bar of justice, you will have some comfort in the fact that somebody, like I said, that they will be playing chess and not checkers.
Yes, sir. Yes, sir. Well, Judge Guidry, thank you so much again for joining us tonight and for sharing your insights on the importance of the judicial integrity and accessibility. We
So,
truly appreciate your time and dedication to serving the people of the state of Louisiana. And to our listeners, we definitely want to say thank you for tuning in and being a part of this important conversation. We also want to extend our gratitude to our advertisers who make this show possible. Math Makes Sense, National Auto and Tire, Sadler's Touring, and Long's Products. Remember, your voice matters. So get out there, go
and
vote.
and
Uh,
vote Chief Judge John Michael Guidry for the Louisiana Supreme Court. Thank you.
that's what I was waiting on. That was perfect. If you could hold on 1 second, that Chief Judge, I'm gonna end the stream and I'm gonna come back to you right quick.
Thank you, sir.
All righty.